Alright, so today we're talking about civil law. We'll actually be talking about juvenile law tomorrow, but today is civil law. So what in the world is civil law? This is disputes between two parties, and remember, a contract has been broken, and a contract is an agreement between two people. So one side or another did not keep their word, did not hold up their end of the contract. And these two parties are called the defendant and the plaintiff. So the plaintiff is making the complaint, and if you look here where my mouse is, the word complaint, if you put IFF at the end of the word complaint, you get plaintiff. So this is the person who is actually mad about something, who has been harmed or abused. And the defendant is the person who is being accused of wrongdoing and breaking the contract. So the plaintiff held up their end, and the defendant did not. So, there's four big examples of civil law and what it looks like. The first of which is divorce. So, divorce, let's think about the contract there, is a marriage contract. When you take your vows, I vow to love you forever and ever, till death do us part. I vow to love you in sickness and in health, for rich or for poor, and love you and only you, whoever that person is. So, if one or the other spouse breaks their marriage contract, that marriage will end in divorce. And divorce court is a separate court, but still within the realm of civil law. Our second example is a custody dispute. So within a divorce, you might have a couple who has children, and one or the other spouse would like to have full custody or maybe joint custody of a child. So these two end up in family court, which is, again, a part of civil law. Money issues is another big thing. So if a tenant doesn't pay their landlord for a couple months, or if someone makes an agreement with someone to pay money, or is supposed to help someone maybe start a business, or help them pay for, if you help maybe one of your friends pay for renovations on their house or for something else, and doesn't actually end up paying them back, you could take that person to court. You could sue them for whatever money they owe you. And the last one is tort law. This means that someone has either been abused or neglected and has suffered injuries because someone did not do their job or abandon their job. You see this a lot in medical cases. So if you've ever heard, if you have been diagnosed with mesothelioma, you may be entitled to compensation. A TV commercial like that would be part of tort law. You might have also heard of the lady who sued McDonald's for damages and compensation when she was burned. Okay, I talked about that in the last educanon. But tort law, someone has been abused or neglected. You might also see this in nursing homes. Maybe if a little old lady has fallen in the nursing home and she lays there for a couple hours because the nurses aren't there to talk to her or to help her out, and no one notices, then they have neglected her there. And let's say that she's broken her hip, and then something else happens and she has complications from it because they left her on the floor for 2 hours because no one was doing their job. That's an example of tort law. So civil law has four big examples: divorce, custody disputes, money issues, and tort law. So how is civil law handled? We know the process for criminal law has 8 steps. Well, there's in court, which has a similar process to criminal law, but only 6 steps. And then out of court, there are 2 separate ways to handle civil law or disputes out of court. So let's start with in court. Again, there are 6 major steps, 2 less than the criminal law process. Our first one is a complaint. So a plaintiff, the person who has been wronged or has suffered injuries, they issue a formal complaint to the defendant for damages or compensation. And compensation is money for injuries or debts. So, one side officially issues a complaint to the other. In the second step in the process, you have summons, where the plaintiff, the person who's doing the complaining, issues a formal request for the defendant to come to court and settle the dispute. Okay, so if you've ever seen a commercial or a TV show where someone knocks on someone else's door and says, "Good morning, such and such, is this your home?" And you say yes, and they hand you this big envelope full of papers and they say, "You just got served." Well, that means that you have been summoned to civil court, some kind of a civil court for something. So, remember, coming to court, you might have thought of this, but a subpoena is something when you are told to, it's a formal request for you to come to court. It is an order. You have to go. A summons means that you are being sued for something. A subpoena, you have to go to court. You might not actually be the defendant in a case to get a subpoena. You might be a witness, or you might be a juror, something else like that. But summons and subpoena are two different things. A summons is a request for the defendant to come to court and settle the dispute, and a subpoena means that you have to appear in court for something. Subpoenas are usually done for criminal law, and summons are for civil law. All right, number 3 is response. The defendant and his or her attorney file an answer and a motion. Not this motion like this guy. Thought that was a funny picture. But they issue a response and they say, yes, we are okay with these charges, or no, we are not. Okay? So they issue a motion, like a motion to take this to trial, or a motion to have a hearing. Our 4th step in the process is pleadings. The plaintiff and the defendant both file pleadings documents, and the complaint and the answer to the complaint are both collected together. So the plaintiff pleads the victim of X, Y, and Z, and then the defendant says, this case is not correct, these facts are incorrect, I don't remember the situation this way, or maybe they do remember the situation the same way. If they do say that, yes, I agree to this, I did this, I admit to it, if they plead guilty to this, then the process stops right here. However, if they say, no, this did not happen this way, we're going to trial, the next step in the process is the trial. So the plaintiff presents their evidence to the judge or the jury. Depends on which. In some civil cases you do have a jury, in some civil cases you don't. It depends on how severe the damages are, or what kind of case it is. And the defense presents their case. So in a civil proceeding about divorce or custody battles, you probably won't have a jury. You will probably just have one judge who makes a decision based on the attorneys present for the plaintiff and the defendant. However, if we're talking about maybe court law or money issues, you probably will have a jury if it's above a certain amount of money. So if you have slipped on, I don't know, let's say a banana peel at Walmart, or if it has just rained and you have slipped and fallen and broken your hip in the middle of Walmart and there wasn't a sign that said caution wet floor, you can sue Walmart for not telling you that there was a wet floor in front of you. So you might have a jury there. You might sue them for all of your medical bills, all of the time that you had to take off of work to recover from your medical issues. You might sue them for that. So plaintiff presents evidence to the judge or the jury, and the defense presents their case as an answer. Our next step in the process, our last one, is the verdict. And this is a decision on who wins the case. If the defense wins, the case is over and nothing happens. No one has to pay anything. If a judge and the jury together decide that the plaintiff is being ridiculous and the defense wins, no one has to pay anything. However, if the plaintiff wins, the defense has to pay compensation. And that amount will be usually settled on by the lawyers, and sometimes the judge will help in that. Whatever amount or whatever things the defense has to do, or the defendant has to do. So there are 2 ways to settle civil disputes out of court. They're arbitration and mediation. They sound a lot alike, so make sure you don't mix them up. The first one is arbitration. 2 parties decide to have one or more people or persons, arbitrators, settle the dispute in private. So they're not in a courtroom, they don't have any of the court dates or the issues with lawyers or anything like that, and they both agree to follow whatever resolution is made. So this is usually involving a third party. Okay, so an arbitration is usually involving a third party. Fun fact, Judge Judy is technically an arbitrator. Although she says her title is Judge Judy, she is technically not a judge. Let's think about this. When 2 people go on Judge Judy, one is usually suing for something petty and ridiculous. Let's say maybe $800 in rent and damages on property or something like that. Judge Judy hears both sides of the case. Usually that goes pretty quick because Judge Judy doesn't take any prisoners. But she'll hear the case and she decides and she says, you pay him this amount of dollars or you pay her this amount of dollars. I don't want to hear any more about this. She slams her gavel down and says, go on, get out of my courtroom. Next. So technically, she's not a judge. She used to be a judge. She was a very high-ranking judge, very powerful lady. However, she discovered that she could make more money in a fake courtroom, well, a semi-real courtroom, on TV, being an arbitrator than she could being a judge, so that's what she does. Our other way is mediation. So both lawyers, or attorneys, help these two parties come to a decision, and there is not a third party involved in this. Both parties trust each other to abide by this agreement, but they're not technically legally bound to follow it. Okay? And if they don't, then they might end up going to court anyway. So, again, our two ways to settle disputes out of court are arbitration, involving a third party, and mediation, when the lawyers help the two parties come to a decision. So, this has been Civil Law.